All right, how's everybody doing today? Like you said, my name is Chris Ryan. I am the West Territory Risk Consultant with LGRMS. I've been with the company almost 15 years now, but before that, I was actually County Clerk HR Director in Sumter County for 5 years. I have a master's degree in business and a bachelor's degree in human resources. I love what I do, y'all. I really do. I love the fact of being able to talk to people, teach, and just the fact of having the opportunity to come before you today and kind of talk about a topic that's kind of near and dear, and it's talking about discrimination and harassment training for supervisors. And the reason it's so important is that supervisors are our key when it comes to making sure this stops as soon as it starts. So a little bit about some costs for workplace harassment. In 2020, the EOC recovered $137.3 million for employees who alleged harassment in the workplace. That is crazy. There is no reason this should be happening. The mental and physical and economic harm that it puts on the employees is immeasurable, and it's extremely long-term. Even non-harassed employees are impacted. We'll kind of talk about that throughout the presentation too. And workplace causes decreased productivity, increased turnover, low morale. And right now we're having a tough time keeping people. People are calling this the great getaway, and people are just leaving workplaces to go and do it at home and work from home. And we don't have enough people to staff the positions we have currently. So definitely something like this could definitely hurt you. So simply having a policy is not enough these days. What you need to do is make sure, especially in your office, your department, or whatever, you want to make sure your employees know what type of harassment or anti-harassment policy you have. They should know what sort of conduct they cannot engage in. They should know what they have to not put up with. And we'll talk a little bit about some of the things like that. But your employees also must know how to report it if it's happening to them. Now, most of the time when I do the employee section and I ask that question, it's getting a little bit better, but it's still, you want to make sure everybody understands, from part-time, full-time, temporary, it doesn't matter. We've got to make sure everybody understands our policy. So the things that make us unique are the things we like to pick on each other about. See, cities and counties are like big families, and we love to pick on each other, but I tell you what, we will protect each other too. So when we start talking about what could be considered harassment, how about this one? I wish that old man would hurry up and retire. He's just taking up space. Now, a lot of people, oh, that's just them joking about his age, nothing really there. But you got to think about this. This is age discrimination. We'll talk about that in the presentation. How about this one? You tell somebody they look nice today. A simple thing like that could get us into a lot of trouble, and it's usually because of a frequency level, unless there's a big difference in saying you look nice today and you look good in them jeans. Everybody knows that. But see, usually when it comes to something like that, we know that there's a frequency level, and this is being done over a period of time. We'll talk a little bit about the differences in the type of harassments too. But you got to think about this. It could be as simple as this when it comes to things that make us unique. How about nicknames? A lot of times I always talk to police, fire, public works, stuff like that, and I always ask the question, does anyone out there have a nickname that more people know you by your nickname than your real name? And a lot of times I see smiles. So my first question is always this. How about this? Can you tell me the nicknames? And most of the time they look at me and go, there's no way we can tell you the nicknames. If you can't tell me the nickname, then we probably have an issue, and it could lead into a protected class being violated, okay? So illegal harassment is based on the protected characteristics of sex, age, race, color, disability, handicap, creed, national origin, ancestry. And June 26, 2020, sexual orientation was officially added in Georgia. Now, most of my cities and counties already had it in their policy because we knew it was coming, but that's when it was officially added to the statute. So harassment is a course of conduct, and it's usually directed at a specific person, and it reasonably could cause emotionally distress in such person, and it serves as no legitimate purpose. One of the first questions you should ask somebody if you see somebody doing this is, why are they doing it? Now, I've heard a lot of excuses, but the one that always kind of touches base is, I thought it was funny. Everybody else was doing it and everybody else was laughing, and I just thought it was okay. But you got to remember, what you consider to be funny may not be funny to everybody else. You've always got to make sure of that, because just because a person laughs doesn't mean that they enjoy it. They might be laughing because of the situation. So you need to be careful what you say and do around people. And as supervisors, we've got to have our eyes and ears open to see what's going on, because most of the time we're the last ones to know. But we need to get it to where we're the first ones to know if this is happening, so we can stop it at the initial point. It's usually words, gestures, and actions which tend to annoy, alarm, or abuse another person. And I always stress this to my employees and stuff like that. Even people that are not directly in line with this conversation can be considered themselves as being harassed. So you want to make sure there's no mistreatment of protected classes. And guess what, y'all? It's against federal law, not state, not local, federal law. So if we go to court for this, which is very unusual, you know, most cases are mediated out. But if we go to court for this, we'll go before a federal judge, and he or she will decide your fate, or they will decide your fate. So when we're usually looking at employment discrimination, we see it in two different types. Let's say discrimination is intended against a group, which means it is focused on that group. We call that desperate treatment. And I always give the example like this. So the city or county authority said, this year we're going to offer early retirement, but instead of saying you get an option of choosing it, they start pointing to the people that must take it. And it's usually at a protected class. It could be an older workforce pushing them out of the workforce. And yes, that is illegal. Now, public services has a little bit different standards because of their physical attributes that they have to maintain and everything, but it's still there. Or maybe even be unintentional, because a lot of cities and counties, and they hate this word, it's called downsizing. This is desperate impact, because when you start downsizing, who are you going to affect? And it could be a group of protected individuals. So that's why you have to be so careful. So Title VII of the Civil Rights Act of '64, it's enforced and administered by the EEOC, and we'll talk about them in a little bit, and the Department of Justice. You must have 15 employees to abide by this statute, and a lot of my cities and counties and authorities do. It prohibits discrimination in harassment of an employee action against a protected class. And right now, when it was passed in 1964, there was no individual liability. So what did that mean? Employers were solely responsible for anything that happened to the employees while they worked there. Now, the caps on damages with 100 employees or less was $50,000 compensatory and $50,000 punitive. However, punitive damages could not be imposed on local government, so it's just that compensatory $50,000, but still, $50,000 back in '64 was a lot of money. So when we talk about Title VII and retaliation, it's included in Title VII provisions. Who's protected when it comes to retaliation? It is employees, former employees, and applicants, okay? And it includes the anti-retaliation policy. And retaliation is broadly defined as almost anything that could make the alleged victim regret coming forward. And I always say it's natural instinct that if somebody submits a harassment claim against you, you want to see and go to that person and talk to them and say, what did I do? What did I say? But that could lead into other stuff that could be considered retaliation. Sometimes it may even lead into physical altercations, which that's a whole different situation then. And we don't want stuff like that to happen. So things that I've actually heard of when it comes to retaliation, I've heard of sugar and gas tanks, busted windows, slashed tires, and yes, fights in the parking lot between the two people because you're mad, they're mad, and it leads into an altercation. And we don't want that to happen either. So what conduct is protected when it comes to retaliation? Imposing an unlawful employment action, which means pretty much, well, they were whistleblowers. There was something going on in that environment and they decided to do something about it. Now, also making a charge of discrimination, you're kind of protected a little bit. We'll talk about that in just a little bit too. Testifying, assisting, or participating in any manner of the investigation, you are protected. However, just because you complain about harassment doesn't mean you have this thing called a magic shield around you. And that's what employees sometimes think, that all of a sudden they're immune to any type of discipline you're going to do for them or do to them. And that is definitely wrong. If you would discipline a normal employee for the same offense, you can discipline that person. But if you ever have a question as a supervisor, please make sure you contact and check with HR before we do something that we can't come back on. So just as long as it's legitimate and business-based, we're good. Now, in 1983, there was a statute that came out, and it changed Title VII forever because it was unique to the public sector. And guess what now? Individuals can be liable. So I usually stress this to the employees and everybody else I talk to when I teach this stuff. You can be charged individually in a court case. So think about this, a $50,000 claim. The city and county have done everything they were supposed to do to make sure you're knowledgeable of the policy and everything, and you do it anyway. You may be held liable and have to go by yourself to pretty much settle this case. And I don't know about y'all, but I don't make that kind of money. And guess what? The 1983 statute also said there's no cap on damages, y'all. That's why we hear of multi-million-dollar claims when it comes to harassment. It was good news for the public sector. It allowed qualified immunity. Now, that means that employers were not automatically responsible unless they did not do their due diligence to make sure every employee knows the policy, understands the policy, and had no questions about the policy. That's why it's so important to talk about this at least once or twice a year, and you're supposed to get training on this at least once a year also. Now, the act that we want to talk about now is called the Pregnancy Discrimination Act of 78. It was amended. The amendment was made because of a Supreme Court decision. Unfortunately, what used to happen before this became an act, people that were found to be pregnant in the past, as soon as the employer would find this out, they would go ahead and fire this person on the spot because you're my primary caregiver. We don't know if you're going to be here every day, and we don't want to take that chance, so we're going to go ahead and let you go. Now, the Pregnancy Discrimination Act runs concurrent with the Family Medical Leave Act, and it allows an employee and their spouse, so that's an extra little part, to take some time off due to a pregnancy, due to a childbirth, due to adopting a child, fostering a child, or related medical conditions, and still have that ability to come back and assume that same position that you left. So there's the benefit right there. Now, the Equal Pay Act, it is limited to sexual discrimination and the payment of wages, because unfortunately what happens here is that people are not getting equal pay for equal work. You hire two people at the same time with the same qualifications, the same job descriptions and everything, and somebody's being paid more. You have to make sure you're basing that strictly on their ability to do the job and what they have extra when it comes to that. If they have similar work conditions, similar skills, efforts, and responsibilities, everything should be equal. And unfortunately, where I see it now is entry-level positions where somebody is usually hired and they're paid below entry level. And my question is always this: why? And I always hear this person is not qualified for the job. Well, a couple of questions that I usually ask then is, did you interview this person? Did you hire this person? And if they've done those two things, guess what? They have actually qualified the person for the job. So it's time to bring them up to speed when it comes to the job and the job wages. Now, some defenses can be is equal jobs, but it's based on different stuff. Let's say they have more seniority, more merit, or more quality of production and stuff like that, or quantity of production. Of course, that person would probably make more money. But if there's any other factors relating to sex or anything like that, sex, race, color, anything that is a protected class, that is not a legitimate excuse. So enforcement on the Equal Pay Act is always upward. Successful complainants can recover back pay, liquidated damages, attorney's fees, and costs. And you start looking at all these costs and stuff like that, it gets very expensive very quickly. Now, the EAP or EPA generally has no individual liability. I don't think that's going to change because most of the decisions are made in upper management, not at the employee line. Now, Age Discrimination Employment Act pretty much what says this: if you are over the age of 40, you are in a protected class. Pretty much what plain and simple. To apply, you have to have at least 20 employees, including state and local governments. So most people already have that. Now, the Americans with this, the ADEA claims subject to the same legal analysis as Title VII that we spoke about, the same retaliation similar to Title VII. Also, there's no individual liability here, and I don't think this one's going to change like Title VII did, just because, like I said, it's usually upper management and everything that's making these decisions. And damages include back pay, front pay, liquidated damages, and attorney's fees. Y'all, like I said, it gets very expensive very quickly. It's almost like open up your checkbook. How much do you really need? And are we going to have to give you a blank check to satisfy this? Please be careful. As a supervisor, you have to know these acts and everything, know these laws. So you're making sure that employees are not being discriminated on these things. Now, the Americans with Disabilities Act, this is one that I usually tell everybody, this is a reasonable accommodation without creating an undue hardship on the company or the city, county, or authority. And that can mean a lot of different things. And the one I usually do is this. We had a gentleman that came back from being in an accident, comes back on light duty. He comes into his office the first day and he's in a wheelchair. And when he goes into the office, he figures out that his wheelchair would not fit up under the desk. So a reasonable accommodation could be a new desk, new office, okay? His request was a $30,000 desk that when he comes in, he pushes a button, it raises, he pushes another button, it lowers back down on top of him. That's not reasonable for a city or county to pay. Now, unfortunately, we have some people that like to joke around and stuff like that sometimes. And even in this situation right here, I've had a couple of people say, well, you can take the air out of his tires or you can take the wheelchair away from him. Y'all, please don't do that. As supervisors, please make sure this is not happening. So reasonable accommodations is something that enables a disabled individual to perform the essential functions. That's what you're looking at, the essential functions of the job. An employee must request a reasonable accommodation. Don't assume this employee is disabled and then you make that suggestion. You let the employee come to you and you base it on the necessity of the job and what is a reasonable accommodation and can this be done by the employer. Always get HR or even your city or county attorney to help you out with this. So some reasonable accommodations we've heard of: accessing the facility to make sure it's accessible, handicap parking or something like that, modifying work schedules. You know what, I just can't be there at 8:30. Can I be there at 9? If that's able to do that and your department or office is able to do that, that is fine. But you got to remember, now they have this thing that they're supposed to be there at 8:30. So all of a sudden 2 months goes by and 8:30 they're there every day, and all of a sudden they start coming in 8:45, 8:50, 9 o'clock. you can discipline that person by not meeting the reasonable accommodation that they requested. But like I said, always get HR and make sure everything's on the up and up. Maybe a qualified reader and an interpreter. I've seen something on the phone to amplify the sound, something reasonable. And it takes the city and county authority to kind of look at the accommodation to see if it's reasonable. So what's not some reasonable accommodation? If you are changing or eliminating any of the essential functions of the job, that's not reasonable, okay? Something that poses an undue hardship on the employer, or how about this, jeopardizes the health of another employee. You can't do that. That's not a reasonable accommodation. You don't want to have somebody have an accommodation that could possibly hurt someone else. So like we always say, when it comes to harassment, supervisors have always been the key when it comes to successful implementation of a policy like this. Because I can go ahead and guarantee you, if you don't stand behind it and enforce it, it trickles down and your employees are all of a sudden like, well, you know what, I guess it's really not that important. And I've heard this too many times. Oh, that's just another policy that HR has passed down. They don't know what we go through, so we're not even going to worry about this policy. But you have to look at this because something is going on and we're having to have this type of policy. So retaining supervisors who fulfill duties under this policy is a good way to make sure it goes through correctly. You always want to make sure that supervisors are behind you when it comes to stuff. So how can you tell if a behavior is inappropriate? Would you want it to show up in your local paper? And I understand a lot of people don't have local papers anymore. How about this one? Would you want it to show up online? And as you know, everything that shows up online is true, right? So we got to be careful with that. Is there equal power? We'll talk about that in just a little bit. Would the same behavior occur if my significant other was here and I was speaking to you or you were speaking to me? Would you want this to happen to one of your family members? Probably not. And are both parties initiating and participating equally? Whether it's subordinate, supervisor, or supervisor, subordinate, it is wrong and not the right thing to do. It is inappropriate behavior. So what type of appropriate corrective action needs to be required? You need prompt and thorough investigation process. When you're talking, you need to get the facts on both sides, okay? Don't get one and then make a decision. You need to get both sides. After you reach the conclusion, the corrective action needs to be taken pretty quickly. So if that means this person is going to be suspended, or whatever, it needs to happen as soon as the situation has been taken care of. The last thing you want to do, I can't really let this person go because we've got a big job and I'll fire them on Friday at 4:30 when the job's over with. Somehow or another, they always seem to figure out that this is what's going on, and you don't want that to happen because they can jeopardize everybody's safety and stuff like that. All right, inform the victim of the results of the investigation. Now, a lot of times somebody will come to you and say, okay, I'm submitting this, and as soon as you know something, let me know. But then every day they come back in your office saying, what have you found out? What have you found out? What have you found out? Well, it doesn't happen that quickly, and you just need to get them to understand that this is a process. It's going to take a little bit of time, but as soon as we know any results, we will let you know. We want to make sure you understand that we take this seriously, and we're going to make sure that you know how the situation is going. But if we don't know anything, we can't really say anything yet. Also, most employers felt compelled to err on the side of an over-disciplining employee that violates the harassment policy, even for the simplest things, that single picture joke or email that used to just get a slap on the wrist, don't do that kind of thing anymore. Cities and counties are going, look, for the small stuff, we need to use our progressive discipline and possibly terminate people that way, because if we don't, how bad can it get? And we don't want that to happen. So inadequate remedies would be failing to report it to HR, because you know what? HR just makes a big deal out of it, and we just don't have time. We got a project under deadline, and we need everybody here working. That's not going to work. Telling the complainant to work it out with the other person is the wrong thing to do, because things can happen outside of work that could come back on the city, county, or authority, and you don't want that to happen. Bring them together in your office and clean out the air. No. The last thing you need to do, you need to talk to them separately and get both sides of the story where there's no interruptions and stuff like that, because if you bring them into your office, all they're going to do is argue, fuss, and fight, and it could lead into something that goes outside the organization also. Please don't have somebody come in and do this in your office with the people at the same time. I actually had a city that says, we do this at the same time. And I said, why? Well, this person has a right to face their accuser in a court of law, not in your office. Please don't do that anymore. Doing nothing because the person complaining didn't want to cause a problem. And I hear this a lot. Well, they told me that they didn't want me to do anything, so we just kind of kept it between me and this person. Wrong thing to do, because they may come back later and go, I told this supervisor that this was happening to me over 2 months ago, and they failed to do anything to stop this situation from happening. So no matter if they say they don't want to cause any trouble, you are obligated to take it forward according to your policy on what you do next to help remedy the situation. Now, transferring the person who complained without request could lead into retaliation. Most attorneys will defend you when you transfer the person, or even suspend the person with pay that has the claim filed against them, just to get them out of the situation until you can do your investigation. And the fact that you do it with pay, that allows you to bring this person back. All right, failing to follow up and make sure that the problem is stopped. Well, once you have the claim and you've talked to everybody and you've done everything you're supposed to do, it still is not over, because you got to go back periodically and just make sure nothing else is happening. So not only the fact that it stopped at that point, but it's going to be stopped forever, or as forever as you can do within that city, county, or authority, or that office or department, and let them understand that if this happens again, what's going to happen. Laws have changed and expanded in harassment, but you know what? Lack of knowledge is no defense anymore, because there's so much stuff out there on it. So employers must be proactive in preventing, discovering, and remedying harassment. So as a supervisor, this is what we'll probably ask you to do. Now, don't assume you're going to be the one doing the investigation, okay? But if you are, you meet with the complainant. They'll come to you and want to talk to you. So you meet with the complainant, report and document dates, times, details, everything you can get. Ensure cooperation with the investigation. That not only means you, but everybody that works in that office, because I'm pretty sure everybody knows about it, because cities and counties, we have this thing called rumor mills, and a lot of times it's no longer hardwired, it's wireless, and by the time you know about it, everybody else has already known about it. You want to ensure no reoccurrence or retaliation after the complaint has been made, and support the discipline and remedy that comes down from upper management, because like I said, you're the key. If you stand behind these discipline remedies, the employees will too. So when it comes to report and document, you name the complainant, name the alleged harasser, name the possible witnesses, times, locations of the alleged incident, and description of the incident. The more information you have in writing, the better off it's going to be. And there might be, the employee may have information that they want to give to you about what they've been facing too. So they might have it written down already too. Use that, make copies of it, and give it back to them, but you got to make sure you have documentation, because a lot of times I hear this: if it's not documented, it never happened. Unfortunately, that's not true, because as soon as we have to go to court, everything comes out, okay? We want to make sure we have as much documentation as possible. All right, ensure cooperation with the investigation. Don't assume that you'll be the one that conducts the investigation, like I said, but whoever does it, cooperate with and facilitate the investigation, and ensure your subordinates cooperate. So if anyone knows anything, they're supposed to come forward and talk about it, or they might should be treated as such and is subject to maybe disciplinary procedures. So we want to make sure that everybody understands that we're not going to tolerate this, and this needs to stop. So if you have information on it, let's go ahead and get it out in the open. Let's take care of it and make sure this doesn't happen again. All right, make sure there's no reoccurrence in the retaliation. Take formal steps to eliminate and minimize contact between the complainant and the alleged harasser, at least during the investigation, because you want to make sure that's separated. Take action being taken if the alleged harasser's best interest is not based on determined and the complaint is valid. A lot of people say, well, what if this complaint was not valid? And unfortunately, we've had people that say, you know what? I don't like my supervisor, I don't like my coworkers, and I know if I submit a harassment claim against them, it'll change their life forever. And they're doing it just to be mean. And what I usually tell the employees in their section of the harassment class is that if you are that unhappy with your job and your coworkers, it's best just to find another job. Don't make everybody else's life miserable. But unfortunately, the EOC has said that we can't discipline in the harassment section because it may give a chilling effect to the people that actually have a legitimate claim and they won't come forward. And we don't want that to happen. So we need to possibly discipline them in another section of the policy, especially in law enforcement. It could be lying under oath or something like that. I ensure that the alleged harasser knows his rights. And just because this person has a claim filed against them doesn't mean they did it. That's what the investigation process is for. So you're really not supposed to treat them any differently because it could come back and bite us too. Support the discipline or the remedy. It's critical, okay, to have an effective anti-harassment policy. And your lack of support as a supervisor will definitely be obvious to everyone. And the subordinates will take cues from you. So the legal definition of workplace harassment: unwelcome or unsolicited speech, conduct based on protected classes that creates an intimidating, hostile, or offensive work environment, or interferes with job performance or otherwise adversely affects the employment or the performance of the job. And unfortunately, we had a situation where there was a supervisor that when he walked into this employee's office, he always walked behind them and would start rubbing, and everybody saw this, y'all, but nobody did anything. As soon as you see it, whether it's in your department, your office or not, you're obligated to stop it as soon as you see it and make sure it doesn't happen anywhere in your work environment. All right, so quid pro quo, Latin meaning is this for that. So it's an exchange of services, so to speak. The submission to rejection of sexual attention is made implicitly or explicitly, depends on the vulgarity of the person. So we had a guy that had 4 ladies working for him, and on a Friday afternoon, he calls the ladies into his office and says, ladies, there's this raise I have to give at least to one of you. Who really wants it? I'll be at my lake house all weekend. That little simple statement got us into a lot of trouble, y'all, just because it's assumed of what's going to happen at that lake house to get that raise. But also remember this, it can happen inside or outside, on or off the clock, especially if you go to training. And I've heard this too many times, oh, what happens at training stays at training, and it doesn't. Supervisors know this, it usually beats you back, and you want to make sure that you're not doing anything that makes your city, county, or authority look bad. So the best policy when it comes to this is the money where you get your money. And the way that we can actually work on this is there's a policy, it's called a fraternization policy or no dating policy, that pretty much will say supervisor-subordinate relationships should not happen. If they do, somebody may be terminated. And unfortunately, usually the person that needs to be terminated is the supervisor that should have known better. So we don't want this to happen. And I'm not crazy enough to know that it doesn't, because we spend a lot of time together and relationships do happen at work. But we got to stop it as much as we can, especially when it comes to supervisor subordinate. All right, hostile work environment It's usually conduct or comments that is unwelcome. It's offensive to a reasonable person. So would a reasonable person consider this action to be offensive to them? And it's also based on the perception of the person. So we got to be careful with that too, because sometimes people just feel, oh my God, I feel like I'm being harassed. And we've got to make sure we do due diligence to show them that we're taking this seriously and we don't want it to happen to them. It's usually severe and pervasive, and there's usually a frequency level when it comes to a hostile work environment. And guess what? Intent, it doesn't matter. It's regardless of it. So whether you're trying to be funny or maybe you're just trying to be, do it because somebody else did it to you, it doesn't matter. This should not happen. So unfortunately, things that have happened in the past can't happen today like it used to. And we, as supervisors, you got to have your eyes and ears open. All right, so it's usually speech or conduct that is racial, sexual, etc. It's also, it violates, and protected classes are usually the ones that are affected. So you want to make sure of that. This can happen inside or outside the organization also. It could be verbal, nonverbal, and physical. So let's talk about a couple of those. Verbal, comments, jokes, not accepting no and asking a person out on a date. Okay, verbal stuff. Jokes, slurs, referring to an adult as a boy or girl, cat calls, whistles. And I'll go ahead and tell you, especially some cities, counties, and authorities, if you have inmates that work in your departments and stuff like that, you want to make sure that they're not treating anyone else like this either, because we're just as responsible for them as we are our employees. So nonverbal, gestures, body movements, elevator eyes, no direct eye contact, maybe calendars, cartoons, pictures. And unfortunately, this right here is going to be the death of us, because we know inappropriate information is being passed through these things on a daily basis. And we don't want this to happen. And you got to get your employees to understand that if they have a cell phone provided by the city, county, or authority, it's not their phone, which means it can be pulled at any time. And also, if they have their own personal cell phone and they can prove that you're doing something inappropriate while at work, they'll come after the personal cell phone too. So you want to make sure people understand that. And I usually also tell my firefighters, because they're allowed to bring in laptops, personal laptops, while they're at work, because they're on call 24 hours at a time sometimes, if not more. And you got to treat that phone, that laptop, just like you would anything that the city or county or authority has given you. Calendars and stuff like that, you just have to be very careful. How about this, winking? Now, if somebody winks at you, please don't read a lot into it, because they might actually have something in their eye, or naturally they blink a lot when they talk. So let's not read a lot into winking yet until there's that frequency level there. How about physical? Hugs, kisses, patting, touching, impeding or blocking someone's movement. Now, I'll go ahead and tell you, Georgia is a real big hugging state. We always have been, we always will be. But if someone says, please don't hug me, just don't hug them. Especially with COVID and everything, people don't like to be touched anymore. So this is even more prevalent now than ever. If somebody says, please don't do that, just don't do it, okay? So workplace harassment, quid pro quo, usually it's one time and one time only is all it takes, because it is a supervisor subordinate relationship, and they're usually using their power to get something. And it could be sexual based, or it could be even religion based. Let's say I'm the supervisor and I say, well, if you want to succeed in my department, my office, you got to attend my church. You're still putting pressure on this person to attend the church to order to advance in your department or office. Same situation. All right. When it comes to hostile work environment, like I said, there's usually a pattern that continues unless it's so bad, like a situation I've heard of where a guy had a unique way of welcoming people to work. He would walk up behind them, take his hands, slide into this person's pocket, and move to the front of their body because he thought it was funny. Well, everybody else didn't think it was that funny, because there's no telling how many times that this person had to pick themselves up off the floor, but it only took one time. So usually when it comes to hostile, there's a frequency level, but it can be a one-time incident, just like quid pro quo, if it's severe and pervasive is high. So who can be their harasser? Could be an elected official, could be a manager or a supervisor, co-worker definitely, and a non-employee. So not only do we have to protect employees from employees, but anyone else they come in contact with throughout their day. And I know that's very difficult because you don't have control over those people, but you still have to make sure that they're being protected. So I always stress, if you feel like this person is maybe a citizen or something, has come up to it and started flirting with you or start cussing you out, you have a right to walk away and get a supervisor to take care of this situation. All right? Who can complain? Anybody, also co-workers. Could be male or females. It could be visitors, salespeople. Now, it's a little bit harder to prove because it's not in-house, but it has happened before. UPS worker comes in and delivers a package, and we have people flirting with him or him flirting with other people in the office. And sooner or later, somebody says, you know what, that's just inappropriate. You've got to make sure when you're in the office, yes, we're a family, but we have to be professional too. And what I was talking about earlier, directly or unintended. So it doesn't matter that you're not part of the conversation that's going on. You just overhear it. That's all it takes, y'all, because you're still being affected by the harassment. So as supervisors, that's why I'm saying you have to really know what people are saying and doing around each other. So elements of an effective harassment prevention plan. It needs to be in writing. Everyone must receive a copy of it. It needs to be online or something. It needs to define harassment and discrimination, declare what is intolerable, establish that complaint procedure in place, and everybody needs to know how to do this. And when it comes to a complaint procedure, you got to remember this. This is probably the one policy that bypasses chain of command. Most chain of command says, yes, you go to your immediate supervisor. But what if your immediate supervisor is doing it to you? You've got to have other avenues to go to. That's why we usually stress it's sometimes good just to go straight to HR. But I have seen policies that say any supervisor that you feel comfortable talking to, you can. Now, most of my policies have said you either go to the supervisor that's over you. If you don't feel comfortable, you go to HR. So definitely a different avenue to go to if you don't feel comfortable. Provide training to everyone, no matter what. Ensure prompt and complete investigation process, maybe even go through the steps of what you'll do in the investigation process. Maybe not the timeframes, because timeframes may vary, but what you're doing in the investigation process. A prompt corrective action and disciplinary procedure, and a formal retaliation policy that also needs to be separated from the harassment and discrimination section of the policy. So it needs to be its own separate policy. So a scenario that we're going to go over. Roy is a longtime battalion chief for municipal fire department. For decades, he has employed a management style that promotes a family atmosphere at the fire stations he oversees. In doing so, Roy casts himself as a firefighter father and other firefighters as brothers and sisters. In keeping with this management approach, Roy often hugs the firefighters, both male and female, at various points throughout their shift. Tanya, a recently transferred firefighter who never previously worked under Roy's command, she is not a hugger and consistently pushes Roy away when he attempts to hug her. Roy is persistent in telling Tanya, you just need to understand that we're a family here. Family members hug each other, so you might as well go ahead and get used to it. Tanya files a sexual harassment complaint with the city HR director, who subsequently holds a meeting with the city manager, the fire chief, and Roy. Roy is told to stop hugging everyone. He responds by saying, I consider these firefighters to be my sons and daughters. I've been hugging them for over 30 years and I'm too old to stop now. So you might as well go ahead and fire me. In aspiration, the city manager asks, well, Roy, can we at least get you to stop hugging the women? Roy is sad but agrees to the compromise. From that point forward, he only hugs the male firefighters. Whenever a female firefighter attempts to hug him, he pulls away and says, nope, sorry, women don't get hugs anymore. After several weeks of this, Sarah, a firefighter assigned to one of Roy's station, files a grievance with HR alleging Roy is discriminating against her and the other female firefighters by withholding hugs for them. It kind of sounds like Roy is in a bad situation. Danged if you do, danged if you don't. So what do we need to do? All right, since Roy hugged both male and female subordinates, was Tanya's complaint invalid? And it was not invalid because she told him multiple times, please don't hug me. Then she actually pushed him away, y'all. Physically said, don't touch me anymore. So now he is touching her without her permission, which could lead into a civil case, which we don't want that to happen either. So they need to understand that we can get into other trouble too when it comes to situations like that, or a criminal case. All right, since Roy only hugged male subordinates after Tanya's complaint, was Sarah's complaint invalid? And her complaint wasn't invalid either because she felt like she was being discriminated against by not getting hugs, and she's in a protected class, so he was actually doing this against a protected class. Now, unfortunately, I don't think Roy's going to be on the hook for this one because he was actually told by somebody to stop hugging the females, and it was actually done by the city manager. So the city manager might be on the hook for this and not Roy, but he still is going to have some problems with it. So if the city had known for years that Roy hugged all of his employees, were his rights violated when he was instructed to stop? No, because there's no law that says you have a right to hug anybody. And as you know, things that were welcome 20, 30, 40 years ago can't be done today. Things that were done 2 years ago can't be done today. And things that were welcome yesterday may not be welcome today. So every day is a different thing. So some of the things that the city could do to handle Tanya's complaint differently, which is the next question. How about this? The city says from this point forward, our policy says you cannot hug anyone while at work. Nobody's grandfathered in. The policy says from this point forward, and if somebody is caught hugging, unfortunately, whether it's Roy or whoever it is, you got to start disciplining those people. Now, that's a little bit extreme, but that's one way to handle it. Or how about this? Roy says, you know what? I've been doing this for over 30 years and I'm too old to stop now. You might as well fire me. Unfortunately, that might be the only avenue you have, and you might have to let Roy go. Now, you don't want to do that because that's a veteran, a 30-year veteran, and you want to make sure you keep that experience. But there's an issue there that you need to take care of. So let's say that Roy is fired and Tanya goes back to work. Okay? So unfortunately, as you know, just because Roy is gone, the case is not over because you have to go back periodically to make sure Tanya's not being retaliated, harassed, or discriminated against. For a month or two, this is something that could take years to do. Years, because you want to make sure that she has a viable working environment that she doesn't feel threatened in. And unfortunately, she's going to have some repercussions. That's just natural because people are going to be like, oh my goodness, you know, they fired Roy because of this. So you never can tell. So the case is not over. You always got to make sure everybody has a good working environment. So how about this one? Roy's not fired, but Tanya goes, you know what? I quit. Now, just the same way, just because the person that made the complaint is gone, doesn't mean the case is over with, because she can actually come back and still sue the city, county, or authority, okay? Also, the problem is still there because now, let's say that she had the courage to come forward. So now somebody else has the courage to come forward and they may be of the opposite sex, okay? So just because that person says, you know what, I didn't want to say anything, but now since I know that we don't have to tolerate this and have to stand for it, I don't want Roy to hug me either. See, the situation's still there and you want to make sure you take care of the situation. And I always give this scenario also. Let's say that Tanya's gone and about 3 months later, you're sitting there, especially when it comes to a fire station, because anyone can answer the phone there. and a call comes in and says, how you doing? My name is Chief Ryan. I'm the fire chief over here at such and such city, county. And I have a question. We have a young lady named Tanya that is over here applying to be a firefighter, and she put you down as a past reference, work reference. So what can you tell me about her? And this happens all the time, y'all. So you got to get your employees to understand, and even some supervisors, that making comments can come back and haunt us. Okay? The best thing I can tell you to do and to tell your employees to do is this. If you get something that they're asking about somebody's employment, say, hold on one second, let me get you in contact with our HR department. They can answer any questions you have. Just because, and say that you said something that was true, it doesn't matter. And she says, well, who actually told you this? That could come back as a civil suit because she wasn't able to get the job because of this. You want to make sure that you're only given certain information, and HR is the best place to do it. Because usually when HR gets it, they're only going to answer a couple of questions. Yes, they were employed here, the dates they were employed here, and probably the job description or their job title. And the reason that's the only ones we're going to answer is because most attorneys have told us that's what we need to answer. Now, some may say, if you'd like any further information, you may submit an open records request. They may say that, they may not. But one question somebody's always asking is, would you rehire this person? And unfortunately, attorneys are fighting with this one because who are you talking to when you're actually asking that question? So you call me and say, would you rehire Tanya? And I'm not in the HR department. And I go, I didn't say a thing, but you know by my reaction that I wouldn't rehire Tanya. Unfortunately, it may be the exact opposite too. I may pick up the phone and go, oh my goodness, Tanya, that was the best employee we've ever had. We can't, it was hard to function without her. I was very devastated when she left, but I'm glad that she ended up somewhere else. So she's a good worker. And I hang up the phone, I'm thinking, oh my goodness, I'm so glad this person's gone and it's not my problem anymore. And unfortunately, as you know, we see this all the time. We see people that hop around from city to city, county to county, and have done something, not saying Tanya, but have done something wrong, but they're hired at another place because this is what I've usually are hearing. We just need somebody that's breathing. No, we don't. When it comes to situations like this, we want to make sure we get the right person for the right job. And I know that may take some time, but it's going to have to take some time. So you want to make sure that the HR is answering these questions and answering them only. All right, any questions? Dan, any questions out there?
Let's see. Any questions? Here's one. Reasonable sounds subjective. Would it be feasible to put a dollar amount or salary percentage into a policy? For example, $600 per week salary, and we are willing to make an accommodation up to 1 month of salary.
I am not real sure about that. I've never had that question. Definitely that would be a good question for our helplines. The ACCG and GMA have helplines on the HR side. I'm not real sure if you can do that or not. And like I said, I don't want to say yes or no because I don't know the correct answer to tell you.
So here's what I would suggest. If you can, please email me that question and I'll forward it to the prospective attorneys to see if we can find that answer. Thank you very much. This is a good webinar. Thank you, did a good job. Okay. Any other questions? Great job. Any other questions and or comments? Will you provide feedback to everyone? Well, again, I'm going to provide, if this is what you're asking, I will be sending out the presentations and the webinar links to the recordings to everyone that registered for the training. So if that's answer your question, let me know. If not, let me know that. Thank you for the great webinar, great information. Okay, Chris, I think you got you hit most of the points. So if you do have any questions or suggestions, here's another one. Instead of sexual harassment, what about discrimination that's not directed at any individual?
It's really the same situation. It can be direct, indirect, or whatever. If this person's being affected by what's going on, then they can file a charge. Whether it be harassment, whether it be discrimination, because maybe this person that you're talking to doesn't think it is, but this person over here does. And they're hearing what you're saying, and that's all it takes. That's why you have to be so careful what you say and do around people.
Here's a question for me. How can we download this webinar and the last one? So I will be sending out links to each of those. Those are included on our the LGRMS YouTube website. But when I send up, if you see an email says upcoming webinars, all those links are posted on that. But I will be sending the links to the recordings to everyone that registered for this. And thanks. Any other issues? Good class. I agree. I want to share with fellow council members and mayor. Excellent. Yep. Thanks for the content. Thanks for the presentation. Okay. Well, with that said, I will say adieu to all of you. Thank you so much, Chris. Great job.
Okay.
Take an extra 5 minutes tomorrow, and we'll let everybody get back to work. Thank you so much.
Y'all have a good one. Bye.